What, there was some queries that government was processing the matter and there were some queries, certain queries regarding the hearing. There was a direction to conduct a hearing. So that query was sought from the director. And accordingly, yesterday also, the director has clarified that point also.
No, now at what stage the matter is pending?
It is in the government for, now government will send it to the finance department for necessary endorsement of the finance department.
No,
Before
since
that-
when it is pending with the government? Since when?
In fact, Lordship, for the last
Hmm?
2-3 occasions, because the joint committee had recommended a name of the petitioner. Thereafter, with the report, the director had sent it to the government. Now, government of.
Joint committee has approved the proposal.
Lordship.
Joint committee has approved the proposal.
Has recommended.
Now
right?
the matter is pending before the
Now-
government.
Now the director, with the report has sent it to the government. And the government is processing the matter and in the meantime, certain queries were raised. Lordship will find the letter of the secretary, commission secretary dated 10/6/2026.
Hmm.
And that query was yesterday itself clarified by the government,
Hmm.
by letter dated, director, by letter dated 11/6. Lordship.
No, that's
So I'm
all right,
sorry,
but when can we expect completion of the entire process?
Now the government will.
Government will when?
It will take some time.
Take some time. Sometimes mean
Lordship,
1 month, 1 year,
1 year not required.
1 year not required.
Within 4 weeks. Lordship.
4 weeks.
Lordship.
4 weeks.
So Lordship will fix the matter immediately after the vacation, Lordship.
Okay.
After
Heard
4 weeks,
Mr. R. Islam, learned counsel for the petitioner, Mr. P. N. Sharma, learned standing counsel for the, no, learned counsel for the contender.
I'm sorry, Lordship, both the letter are same. Actually, I just mistake. I don't remember.
Mr. Sharma, learned counsel for the contender, apprised this court that the joint committee has approved the proposal for provincialization of service of the petitioner, and the proposal is now forwarded by the director to the government, and it is expected that within a period of 4 weeks, the entire process will be completed. And accordingly, he submits that the matter may be listed after 4 weeks. 4 weeks. Taking note of the submission of Mr. Sharma, learned counsel for the contender, it is provided that rest shall list the matter on 27 July. Sorted 4 weeks. 17 July, on which Mr. Sharma, learned counsel for the contender, shall produce the compliance order before this court. The letter, Mr. Sharma has produced some letters before the court, which shall be marked as D, E, F, and shall be tagged with the record.
Obliged. 2 letters. Only 2 letters. One is of 11/6 and
Okay.
other is 10/6.
2 letters.
7.
May it please your lordship.
Hmm.
Trial court record has been received. It may be fixed up for hearing.
Matter ready?
Matter is ready.
Okay. Heard Miss,
D. Devi.
learned counsel for the appellant, Mr. Dekka for the respondent. It is submitted at the bar that service in this matter has been completed and the trial court record has also been received. And as such, the matter may be listed for hearing. Accordingly, it is provided that this is list the matter for hearing. On, we will fix it that it is all matter. Come.
Obliged.
Number 8.
May I please your lordship?
Hmm.
My lord, in this matter, the respondent number one died, my lord. And in this way, my lord, I filed a substitution petition setting aside abatement and condemnation of delay. And condemnation of delay 172 days, my lord. This honorable court, my lord, issued notice. I have taken steps yesterday, my lord.
Yesterday,
My lord,
I number,
my lord, I number 1196 of 1196 of 2026. my lord.
heard. Mr. T.U. Loskor, learned counsel for the appellant. Mr. Loskor submits that he has filed an application for condonation of delay of 172 days in preferring application for substitution of legal heirs of the deceased respondent number one, and also for setting aside abatement on account of death of respondent number one, namely Abdul Halim Loskor, and pursuant to order dated 8/5/2026, he has taken step for issuing notice to the respondent respondent number two.
Respondent number 1 to 1D, my lord. Legal heirs of respondent 1A to 1D,
1A to 1D,
my lord.
1D yesterday only. And accordingly, it is provided that Resis shall list the matter after 4 weeks awaiting service report upon respondent number 1 to 1A to 1D,
1D, my lord.
1D. And in respect of respondent number 2,
2, my lord, I have no instruction, my lord. My learned friend is not there. Mr. A.M. Borguya, my lord.
none appears for the respondent on call. Office note dated 9/6/2026 indicates that no step was taken for issuing notice to the respondent number 2. Learned counsel for the appellant is directed to take step upon the respondent number 2 also by speed post and also by usual process within a week from today. Whether any counsel entered appearance for respondent number 2.
My lord, respondent number 2, whether she is alive or not, I'm not aware, my lord.
Okay, you obtain instruction and take step
My lord,
accordingly.
my lord, that's all. My lord.
Later on, Mr. Borgonia entered appearance.
Well, in this case, one of the higher first one was in fact because this my client is already expired one.
I number
Higher well, first item yes, Malad. 1794 he filed for earlier in this. Those Malad he expired in the meantime, and my learned friend filed substitution petition. Malad there was my
no, Mr. Borgonia, this IA was filed by whom?
Malad this respondent Malad Abdul Halim Loskar. He expired. Therefore, my learned friend filed Malad substitution petition. Malad. So this
It may be closed.
close expired.
This was filed by whom?
Malad this expired person Malad Abdul Halim.
Abdul Halim.
Filed by the respondent, my lord.
Okay,
In his lifetime. Malad.
okay. Heard Mr. A.M. Borgonia, learned counsel for the applicant, and also heard Mr. T.U. Loskor, learned counsel for the opposite party. Mr. Bhuya, learned counsel for the applicant submits that the applicant suffered demise, and as such, this IA become infractious and the same may be closed. Accordingly, taking note of the submission of Mr. Barhuya, learned counsel for the applicant, this IA stands closed.
Now, so far respondent number 2 is concerned, my lord.
He is celebrated like it is different.
Respondent number 2,
Respondent number 2 is alive.
alive. You were appearing for him?
Both, my lord.
Both.
For respondent number 1, my lord, he has filed, my lord,
Yes.
substitute petition, my lord, notice will go, my lord, then I will contact with you.
Okay, later on, Mr. Barhuya submits that he has been representing the respondent number 2.
My lord. Diploma.
Oblige.
Number 9.
None appears for the applicant on call, leaves the matter after a week. In the event of subsequent non-representation of the applicant, appropriate orders shall follow.
Item 10.
But I am for the applicant matter. In this matter, my lord, the service have been completed. TCR also received. So matter
So we'll fix the matter for hearing.
for hearing.
Heard, Mr. Your name, please?
J. Hussain.
Jai Hussain, learned counsel for the appellant, and Mr.
PK Bora for respondent number 1.
P.K. Borua,
Respondent number 1.
learned counsel for the respondent number 1. It is
Alert.
submitted at the bar that service in this matter has been completed and the LCR has been received, and as such, the matter may be listed for hearing. Accordingly, it is provided that recess shall list the matter for hearing after
Alert.
after vacation.
My lord, the name, the council's name of the respondent number 3 may be shown in the cause list, my lord. His name is M.H. Ahmed. His name is not shown in the cause list, my
The
lord.
learned counsel for the appellant submits that respondent number 3
3, my lord.
is represented by Mr.
M.H. Ahmed.
M.H. Ahmed, and his name has not been reflected in the cause list. Accordingly, it is provided that recess shall do the needful in this regard.
But my lord, my name has been shown as A. Ahmed instead of J. Ahmed in the appellant cause list.
Okay, Mr. Ahmed further submits that his name
Jai
has
Hussain.
also been reflected in the cause list as A. Ahmed,
A. Hussain.
A. Hussain,
Instead
instead
of,
of
my name is J. Hussain.
J. Hussain. Okay, recess shall do the needful in this regard. Yes,
Item 11.
May it please your lordship.
Hmm.
My lord, in respect of respondent number 7 and 8, fresh steps have been taken, my lord. Lordship may kindly see office note dated 9/6/26.
heard Mr. Colita, learned counsel for the applicant, Ms. Portakor for the respondent, opposite party number
Respondent number 4.
4. Office note dated 9/6/2026 indicates that neither edit card nor unserved notice issued to the respondent number 7 and 8 received back by the registry till date. So list the matter after 2 weeks awaiting service report upon respondent number 7 and 8.
My lord, may I pray that this is a application for condoning delay, my lord. And my lord, the office note, my lord, dated 10/8/23, my lord. Of course, very early, my lord. The other respondents have received the notice, my lord. 10/8/23, of course, 3 years back, my lord.
So whether the same has been reflected in the order sheet.
That is perhaps. My lord,
You checked it, and if it is not there, you let this court know.
my
Item 12.
I believe your lordship.
This I is for
I is for delay, my lord. So there is a delay of 388 days, my lord.
338
days.
days. Yes, any objection? What is the
It is given there, waited for more than 1 year. That timing was delivered by them. And no explanation to that. Kindly come to their petition.
this appeal is for?
But it was in my favor, award was in my favor, they figured against the order. And they have not deposited the amount of it. Approximately kindly come to Paragraph 6 of their. Paragraph 7, my lord. They have in 6, they have given the, on the page, a number of days in particular month, and 7 they have given the explanation. That the applicants need to state that they came to know about the income judgment and order only on 29/12/23. Judgment was given on 19/10/22, my lord. More than 1 year, my lord. What they were doing, my lord, they are putting the blame on the council, my lord. They should be agile as to the what is the judgment of the court, my lord. That's after they say that they can discuss in the explanation is not sufficient, my lord, in my opinion, my lord.
My lordship, with regard to the knowledge, my lordship, they only came to know on 29/12/2023. As soon as they came, my lordship, on immediately 1 month later only they applied here, my lordship. That is on
Sufficient reason was given.
2024 they applied, my lordship. 7 days back, 7 days later, they got their certified copy. Thus, and then they took, my lordship, 1 month time to reflect and to collect money.
No sufficient reason, my lord.
যোৱাকালি এটা কেছৰ অৰ্ডাৰ আপলোড হৈছে সেইদিনা আছিল ইকুৱেল আছিলে আৰু ইফালে আৰ্টছমেন আছিল অৰ্ডাৰটো ওলাই দিব পাৰিব নেকি In which paragraph of your application you have explained the delay?
My lordship, in 7 only, my lordship, I have explained, my lordship.
Paragraph number
7, my lordship.
7.
Judgment was delivered on 19/10/22. That means indirectly they are putting blame on the council, my lord. Without no explanation took more than 14 months.
No, you have engaged your counsel before
Yes.
the tribunal.
Yes, my lordship, we have engaged both of
Then-
us, my lordship, the applicant here,
Then-
owner and driver. They filed a written statement, my lordship. Then they did not took steps thereafter. They further did not took notice of the case. And whenever we asked, your honor,
Is the judgment expertise judgment?
yes, it is an expertise judgment, my lordship. And it proceeded expertise against us. After filing of the judgment, there none representation was there in respect of applicant number, both the applicants, your honor.
So whatever
So-
is submitting, no evidence to that.
It is there, my lordship. So lordship may come to pay para 4, your lordship. I have stated there also. We both have filed a written statement, my lordship, but it was taken good care of, my lordship, by the council, my lordship. The applicant solely depends on the council, my lordship. With regard to
So they
their,
have not lodged any complaint also against the council. This is with the trend, my lord. I think they very easy to put blame on the council. They should have been agile, they should have taken care of this.
my lordship, at least my delay may be condoned and appeal may be hard on merit, my lordship.
No way, my lord. No sufficient explanation.
From the date of knowledge, my
No,
lordship,
you say you have engaged your counsel
yes,
and the counsel has
they duly filed a written statement, but they did
written a
not pursue.
statement thereafter.
They did not pursue the case, my lordship. With
Whether you
regard
have
to cross
inquired the
examination of
matter
the
or-
evidence and
Whether you have inquired the matter from your counsel
my
regarding
lordship,
the progress of the case.
my lordship, not knowing the nitty and
No.
gritty of the law, my lordship.
You see, there are two decisions of Supreme Court. You take down it. Or you go through the same, it is indicated in paragraph number 4.1. And thereafter you come prepared. Third, Mr. Your name, please.
P.S. Raja, my lordship.
Learned counsel for the applicant and Mr. Bakshi for the respondent,
Yeah.
opposite party. list the matter. What? Next.
Date will be given to the lordship may pursue.
Uh, 19.
I
don't know, Yes, ma'am.
Order to heading.
My lord, the order dated 21/2/24, my lord.
Pardon?
21/2/2024, order dated 21/2/2024, my lord.
It is recorded in the order set?
Yes, my lord.
Recorded.
21/2, my lord.
Then not necessary to record again.
Yes, my lord. Yes,
Service completed.
my lord.
Order already dictated.
My lord.
Lordship have service completed. What are they?
Service completed.
Lordships.
Yes, Lordship.
Okay.
Fixed.
Heard Mr. Alamgir, learned counsel for the appellant, and Miss
Jay Sharma.
Jay Sharma, learned counsel for the respondent.
Respondent number one, respondent 1, 1, 1, 2, 1, 3, and respondent number 2, your lordship.
Respondent number Roman 1,
1, 2,
Roman 2,
1, 3, and.
Roman
respondent
3,
two.
and respondent number 2. Respondent number 2. It is submitted at the bar that service in this matter has been completed and trial court record has been received.
Yes, lordship.
And as such, the matter may be listed for hearing.
Lordship,
Accordingly, it is
fix the
provided
date.
that recessal list the matter for hearing
Vacation.
immediately after reopening of the vacation.
Lordship.
Honor-
List.
Item 40.
May it please your lordship. Your lordship may peruse office note dated 12/5/2026. Respondent number 1 and 2 has filed your wakalatnama and LCR has been received, your lordship. So your lordship,
So
my
service completed.
yes, your lordship, service is
Third,
completed.
Ms. P. Borthakur, learned counsel for the appellant, Mr. Khan for the respondent number 1 and 2.
Time for one.
1. None appears for the respondent number 2, though one galatnama has been filed on his behalf. Since service in this matter is completed and the TCR has also been received, recessal is the matter for hearing immediately after reopening of the vacation. I is for
Stay, your lordship. Your lordship, we can deposit 50%, your lordship.
heard Ms. Borthakur, learned counsel for the applicant, Mr. Khan, learned counsel for the respondent opposite party. This application under Order 41, Rule 5 of the Code of Civil Procedure is prepared by the applicant for staying operation of the impugned judgment and award dated 29/5/2026 passed by the learned commissioner for the workman compensation Moeno in EC case number 19 of 2023. Learned counsel for the applicant submits that connected appeal has already been admitted for hearing and the record has also been called for and the matter is listed for hearing. And in that view of the matter, there is a requirement of staying operation of the impugned judgment and award dated 29/5/2023 and the applicant is ready to deposit 50% of the awarded amount. Mr. Khan submits that he has no objection
That amount will be
and
withdrawn pursuant by the police.
Your lordship, subject to an indemnity bond, your lordship.
the amount being deposited before the registry of this court, the respondent opposite party may be allowed to withdraw the same. Why indemnity bond?
The appeal is not on quantum, your lordship. We have challenged that premium was not paid for covering the risk of handyman, your lordship. That is one of the grounds, your lordship.
Taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. Operation of the impugned judgment and award dated 29/5/2025 stands state. Subject, however, to the condition that the applicant shall deposit 50% of the awarded amount before the registry of this court. And on such deposit being made, the respondent opposite party will be at liberty to withdraw the same, subject, however, to furnishing one indemnity bond. In terms of this, I instance disposal.
Obliged.
15.
May I please, Lordship? My lord, as per office note, it appears that notice upon the sole respondent has not yet been served. AD card has been returned. So sometime before await for service.
Okay. Heard Mr. Mahmood, learned counsel for the petitioner. Office note dated
9.
9/6/2026 indicates that neither AD card nor unserved notice issued to the sole respondent received back by the registry. List the matter after 2 weeks, awaiting service report upon respondent.
May I expect a date, my lord?
Before vacation,
26.
6, obliged.
Item 16.
May it please your lordship. Your lordship may peruse office note dated 8/2/2026. AD card is awaited, your lordship, in respect of respondent number 5.
you are for
Respondent number 1.
1. And in respect of other respondents,
Completed, your lordship.
completed. Heard Ms. P. Portakur, learned counsel for the appellant, and Mr.
Yes, Arapa.
S. Sarapot, learned counsel for the respondent number 1. Respondent number 1. Office note dated 8/2/2026 indicates that service in respect of respondent number 5 is still awaited. Service report. List the matter after 2 weeks, awaiting service report upon the respondent number 5. There is cross objection.
Yes,
Heard, Mr.
yes.
Learned counsel for the cross objector. And you are for
Opposite party number 1, your lordship.
opposite party number 1. Opposite party number 1. Whether you have taken a step upon the rest of the respondents or
Yes, my lord, we have.
office note dated 7/5/2026 indicates that step has been taken upon rest of the respondent number 2 to 6. But no report has been received till date. In that view of the matter, SSL is the matter after 2 weeks, awaiting service report upon the respondent number 2 to 3. No, 2 to 6. 2 to 6. Further, SSL put up one note in respect of, no, after tracking the consignment in the website of the postal department in respect of service of delivery of the notice upon respondent number 2 to 6 after 2 weeks.
Obliged.
Item 17 by DC note.
May it please your lordship.
Mm.
So here, my lord, trustee service was taken in respect of respondent number, my lord. Two, my lord.
You have not filed the affidavit.
No, my lord, the report has not come, my lord, because he is based at Goa, my lord. My last known address is at Goa, my lord. The report has not come from Goa office, my lord. That is why, my lord. Some time may be given, my lord, to file the affidavit.
Respondent
My
number,
lord, there is a,
Two, my lord, two.
yes, Mr. Das.
my lord, there is an I number 3536. My lord, this is for an application for directing the applicant to deposit 50% from the awarded amount, my lord.
But there is an order, my lord, that unless till the appearance of the respondent number two, my lord, that I may be, the disposal of the I may be kept in abeyance, my lord. Disposal of the I, my lord. We have deposited the amount, my lord.
You have deposited the amount.
Yes, yes, my lord.
My
When?
lord, my lord, their basic grounds for the filing the appeal is that the insurance regarding the insurance policy. My lord, they have adduced a DW before the trial court. In trial court, they admitted in affidavit and in as well as in cross that the insurance policy was package policy and premium for the 2% was taken, my lord. So, my lord, as the policy is valid and they have also already admitted. So, as the respondent one is very much poor, my lord, she was only survival on the income of the son. If the opposite already
Okay. Heard Mr.
reposited
Kolita,
amount.
learned counsel for the appellant, and also heard Mr. B.R. Das, learned counsel for the respondent number one. Office note dated 8/6/2026 indicates that affidavit in respect of service of notice by Dusty Mode upon the respondent number two is awaited. Mr. Kolita submits that he may be granted some time to file the affidavit. We are allowed. Mr. Kolita further submits that he has deposited 50% of the awarded
Yes,
amount
my lord.
before the tribunal.
No, my lord, before the registry, my lord.
When?
My lord, 8526, my lord.
Before the
8526.
registry of this court. He has the appellant has deposited 50% of the awarded amount before the registry of this court on
8526.
8/5/2026.
Lordship, may kindly see the last order passed in IA 3536 regarding withdrawal, my lord.
Whether the record has been received from the trial court? Tribunal? Received. You take, however, in the order dated 23/3/2026, in the IA civil number 3536 of 2025, it has been reflected that releasing of the deposited releasing of the 50% of the awarded amount will be considered only after receipt of the record of MSC case as well as due service of notice on the respondent number 2. So since service of notice upon respondent number 2 is still awaited, the issue of releasing the 50% of the awarded amount being deposited, which has been deposited before the registry of the court will be considered after filing of affidavit by the counsel for the appellant in respect of service of notice on respondent number 2. Mr. Das, on next date, it will be considered.
Okay, my lord. Okay, my lord.
Next. After when?
Lordship, we're expecting by next week, my lord.
Next week, after 2 weeks,
After 2 weeks, my lord.
before vacation.
Before vacation.
Before,
my lord.
before
My
vacation.
lord, can it be fixed on 16 July, my lord? I have some cases fixed on that day.
Okay, my lord.
Okay, all right.
16 July.
16th of July, yes.
Yes.
Hello.
Highly up.
May it please, Your Lordship.
Mm.
Lordship, in this case, respondent number 2 has expired. We need some time to find the legal heirs of respondent number 2, Lordship.
Third means shall be a learned counsel for the appellant. You are for respondent number
Respondent number 3, Lord.
3. You,
Respondent number 1.
your name please?
PM Dr. Lord.
BM Dotto, learned counsel for the respondent number 3 and Ms. Devi for the respondent number 1. Learned counsel for the appellant submits that respondent number 2 suffered demise and some time may be granted to implement for implement of the legal heirs of the respondent number 2. Pair allowed rest the matter after 2 weeks.
3 weeks, Lordship.
3 weeks.
Obliged, Lordship.
Item 20.
90.
Last item.
Lordship, Lordship, can be taken after some time, the conducting counsel is in another court.
Who will appear?
Lordship, P. Borai.
P. Bora. So service completed here. TCR has been received. Not received. Okay. Heard, Mr.
Gishams.
Learned counsel for the appellant. And Miss
P. Borai, Lordship.
P. Bora, learned counsel for the respondent. Office note dated 10/6/2026 indicates that no TCR has been received till date. Accordingly, it is provided that this is a issue urgent reminder to the learned trial court for transmitting the record by special messenger. List the matter after 2 weeks.
Item 21.
May it please your lordship, as per office note dated 9/6/2026, TCR records have been received. Lordship may kindly fix the matter for hearing.
I may pay for the explanation.
It was CGC. Heard Ms. Bihani, learned counsel for the appellant, and Mr. Lahore for the learned CGC. For the respondent, office note dated 9/6/2026 indicates that LCR has been received from the tribunal, and as such, it is provided that SSL is the matter for hearing after vacation.
Much obliged.
Item 22.
Let's see, in this case, my learned friend says APR quota respondent number 1 and 2. And regarding respondent number 3 and 4, the same person, Lordship, we have taken step through Lordship court process that may be available, Lordship, and we may be allowed to take fresh step upon respondent number 3 by speed post.
Heard, Mr. Hart, learned counsel for the appellant, Mr. Agarwal for respondent number
1, 2, 3, 4.
1,
1 and 2.
1,
1 and 2.
1 and 2. 1 and 2. Mr. Bhatt, learned counsel for the appellant, submits that he may be permitted to take fresh step upon respondent number 3
Upon 3, Lordship,
by speed post.
speed post.
Speed post. Where allowed is the be taken within a week from today. And the office note dated 8/6/2026 indicates that service report by usual process in respect of respondent number 4 is awaited. List the matter after 2 weeks or 4 weeks. 4 weeks, because you have to take step upon the respondent number 3.
Yes, Lordship, regarding
So,
respondent, I shall take step speed post.
Await service report upon respondent number 4.
3 and 4 are the same person, Lordship.
Same person.
Same person, Lordship. He is the driver, come owner, Lordship.
Okay, let the report come. Mr. Agarwal, learned counsel for the
File the
respondent
cross
number
objection
1 and 2
how you have filed.
submits
Cross-
that
cross
he has not been provided with a copy of the memo of appeal. Mr. Bhatt undertakes to furnish a copy of the same during the course of the day.
Lordship, they have filed cross objection without copy. How they file cross objection, Lordship? Lordship, okay, I shall furnish a copy, Lordship.
Okay. Heard, Mr. Agarwal, learned counsel for the cross objector, and Mr. Bhatt for the respondent number here in cross objection.
Cross objection may be admitted, Lordship.
No, you are representing respondent number 1. 1,
For the insurance company, Lordship.
insurance company.
Regarding other, they have to take step.
This cross objection under order 41 rule 22 of the code of civil procedure is preferred by the cross objector against the judgment and award dated 7/12/2022 passed by the learned member, motor accident claim tribunal number 2, Kamrup and Gauhati, in MSC case number 517 of 2018. Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Bhatt entered appearance and received notice. However, extra requisite copy of the petition of the cross objection be furnished to him during the course of the day. Step upon rest of the respondent be taken by speed post and also by usual process within a week from today. List after 4 weeks. Pardon?
For the sole respondent, Lordship, today I have item 15.
Already passed the order, you take a date from him.
Well, my lord, the steps taken, my lord, service is awaited, my lord.
Heard, Mr. Polita, learned counsel for the appellant.
Respondent number 4 has appeared.
Mr. Colita submits that respondent number 4 has already entered appearance,
Appearance, my lord. He's not there.
but
His name is shown in the call list.
he remained unrepresented today. Office note dated 8/6/2026 indicates that ID card and service report in respect of respondent number 1 to 3 are awaited. Please the matter after 2 weeks, awaiting service report upon respondent number 1 to 3. I is for
I is for stay, my lord. There also a notice has been issued. There is no stay.
heard Mr. Colita, learned counsel for the applicant. Mr. Colita submits that in this interlocutory application also notice was issued and no report has been received till date. Whether you have taken a step in this IA separately? No, in the appeal
Perhaps
itself.
not, my lord. Perhaps not, my lord. I'm sorry, my lord.
Perhaps.
Perhaps not. I'll take steps, my lord.
Mr. Colita submits that he may be granted some
I'll
time
take
to take step upon the respondents. We are allowed to list the matter after 4 weeks.
I love.
Item 24.
Step be taken by speakers and also by usual process within the after that.
My pleasure, Lordship. As per official Lordship, service is awaited, Lordship, 8/6/2026, Lordship. PD card and service report is awaited.
Heard Mr. Sharma, learned counsel for
Dika
the
Colita,
appellant. Office note dated 8/6/2026 indicates that service report in respect of respondent number 1, 2, and 3 are awaited. And LCR is also awaited. Accordingly, it is provided that this is lays the matter after 2 weeks awaiting service report upon respondent number 1, 2, and 3. And also, this shall issue urgent reminder to the tribunal for transmitting the record without further delay. List after 2 weeks.
Masuk.
25.
Service may be awaited, Lordship.
Awaited. Heard, Mr. Bhatt, learned counsel for the appellant. Office note dated 6/5/2026 indicates that neither ID card nor unfair notice in respect of the respondents received back by the section till date. Accordingly, it is provided that this is list the matter after 2 weeks, awaiting service report upon the respondents.
All right.
Item 26.
Lordship, I appear on behalf of the respondent.
Respondents.
Since I'm a practitioner outside of the state, I have arrived last night, Your Lordship, by receiving the summons. I am seeking leave from the court to file the wakalatnama within due course of the day, Lordship.
Okay. You want to file objection in this application?
Yes, Your Lordship, an oral objection, I am here for an oral objection today. Your Lordship permits, we can give a written objection as well, later on.
When?
If Your Lordship is fine with the oral objection, then we are ready for the oral objections today.
Madam, you say you have not filed your wakalatnama till now.
Yes, Your Lordship.
So let it be on Monday or Tuesday. In the meantime, you may file your written objection,
Okay.
if any.
Sure, Your Lordship.
Yes.
Heard, Mr. Day, learned counsel for the applicant, and your good name, please.
Pardon, Your Lordship.
Your name, please.
Miss Vipasha Mrug, MRUG.
Learned counsel for the respondent. Opposite party. Learned counsel for the respondents. The opposite party submits that she will be filing her power during the course of the day, and she will be filing written objection also, and price for granting some time they are allowed. List the matter. Should we fix a date?
Yes, Your Lordship, then
Okay.
we can arrive here on time offline.
19 June.
19th June. Grateful, Your Lordship.
Item 27.
Grateful, Your Lordship.
May I please, your Lordship?
Mm.
Lordship, there is an office note dated 9/6/2026, Lordship.
Mm.
Respondent number 1 and 2 have entered appearance, Lordship, and for the other respondent, the service is awaited.
How many respondents are here?
9. 9.
9.
Copy to yours. Copy to yours.
Third Miss F. Ahmed, learned counsel for the applicant. And Miss Mazhar Bhuiya,
Lordship.
learned counsel for respondent number 1 and 2. 1 and 2. Office note dated 9/6/2026 indicates that neither ID card nor unserved notice issued to the respondent number respondent number 3 to
3 to
9
9.
received by the registry till date. Received back by the registry till date.
Lordship,
Will await
let
service
us wait
report?
for one date, Lordship.
Okay. List the matter after 2 weeks awaiting service report upon respondent number 3 to 9.
Obliged.
Item 28.
The Lordship, as per office note dated 9/6/2026, we have taken the steps via speed post. However, we have not taken the steps through usual process. The Lordship may be pleased to grant 1 week time for taking fresh steps.
Or
Fresh steps via usual process.
usual process. Third Miss
DB Gohai on behalf of H. Borua.
TB Guhai, learned counsel appearing on behalf of Mr. S. Borua, learned counsel for the applicant. Office note dated 9/6/2026 indicates that neither ID card nor unserved notice in respect of the respondent received till date. Learned counsel for the applicant submits that step has not been taken by usual process. Then as such, she may be granted some time to take step upon the respondent by usual process. They are allowed step be taken within a week from today. List after 4 weeks.
DP on.
Item 29.
I take care on behalf of respondent number 2. Today I file Wakala now. Corresponding to.
Service may be awaited in respect of respondent number 1, Lordship.
Third, Soikia, learned counsel for the applicant. And Mr. Das for the respondent number 2. Office note dated 9/6/2026 indicates that service report in respect of respondent number 1 is awaited. Accordingly, it is provided that list the matter after 2 weeks awaiting service report upon respondent number
1.
Respondent number 1. After 2 weeks.
Obliged, Lordship.
Item 30.
May it please, your Lordship? Office note dated 9/6/26 shows that service is awaited in respect of here is appearing.
How many respondents are here?
Only one. So
1.
yes.
So service completed. Any objection in condonation of delay of 92 days? Is
92 days, your Lordship.
no, any objection?
We need to receive instruction, my lord, regarding it.
Okay. Third Miss
M. Doctor, your Lordship.
and Dr. learned counsel for the applicant and Mr. learned counsel for the respondent. Learned counsel for the respondent submits that he may be granted some time to receive instruction. They are allowed to list the matter after a week.
Item 31.
Mobilized.
Maybe the lordship, the IF for release on a 50% amount It's deposited by order dated, height order dated 18/11/2024 in MFA 2024 Lordship. So the amount is deposited, I have checked the deposit list, not deposited Lordship.
If they have filed this petition, Lordship, you find page 3 of the petition.
Yes.
Lordship, the applicant number and document file.
Mm.
SBI General Insurance Company will be the applicant, along with others. And Lordship, in fact, in this particular case, we have the Lordship Photon Construction, a company. And Lordship, he was an employee of RK Construction, RK Fabrication, and he died. But he has not included RK Fabrication as a party respondent and filed the claim against us. Ultimately, SBI General Insurance Company takes care that no insurance of he's having with us. SBI General Insurance subcontractor labor is not covered under the policy. That is why, Lordship, ultimately a whole liability has been imposed on us.
Lordship, the RK
50% as directed by the Honorable for history.
Before that?
History.
Yes.
And Lordship, the applicant is SBI General Insurance Company, whom the Lordship will release.
Pardon?
Applicant is SBI General
Lordship,
Insurance
I
Company.
am for the claimant, Lordship.
Phase 3. They have to amend the cost then.
No, here the petitioner is MS.
Phase 3 of the application, applicant claimants.
The applicant is a Bhirbati Jadhav Lordship, wife of Ram Lawson, who is already dead. He is a deceased Lordship.
Phase 3 of the application.
Phase 2 Lordship, SBI General Insurance Company is respondent in the MFA Lordship. So we make them.
They have written applicant.
Lordship, it is a application mistake, Lordship, but the amount, as per the order dated 18/11/2024, they have to supposed to deposit an amount of rupees 50% AR amount. AR amount is close to 17,99,208. And as per the deposit list of the registry, they have deposited it. So Lordship, allow us to receive the amount, Lordship, the 50% amount.
So any objection in?
But subject to a bond, it can be released, but they have to rectify this, Lordship. If Lordship allow this, I have no objection, but they have to rectify as a rule, Lordship. Subject to a bond, Lordship, because we have no liability. And SBI General Insurance Company is appearing, Lordship. As per office note, notice was not served on 7, but they have appeared.
Okay, we will allow the application, but you file the amended cost item
Lordship, I'll file the amendment cost item.
before releasing the amount. Heard,
Subject to a bond, Lordship.
Lordship.
heard Mr. Gogoi, learned counsel for the applicant, and Mr. Dusami for the respondent. You?
I for respondent number 7.
Mr. Pego for respondent number 7,
SBI General Insurance Company, which is
SBI General
Insurance
Insurance
Company
Company. This application under section 151 of the Code of Civil Procedure is preferred by the applicant for allowing him to withdraw 50% of the awarded amount deposited before the registry of this court in connection with MFN number 59 of 2024. Mr. Gogoi, learned counsel for the applicant, submits that person to order of this court
18/11/2024.
18
11/2024, passed in IA number,
18
ISC
11
number 3504/2024.
passed in IA civil number 3504 of 2024. This
2024
court
in
has
MFA
excluded
59 of
in the
2024.
respondent opposite party to deposit 50% of the awarded amount before the registry of this court. And accordingly, the said amount has been deposited before the registry of this court.
Also, as per deposit list on 27/11/24, they deposited.
Deposit as per deposit list dated
Dated 27/11/2024.
and the applicant herein may be allowed to withdraw the same. Mr. Goswami, learned counsel for the opposite party number 1, 2. You are opposite party number 1, 2.
Lordship, my senior counsel is for opposite number 1, Lordship.
One
applicant.
One appellant. He's the appellant.
Okay, appellant.
Goto Construction is the appellant lordship in the MFA.
Submits that he has no objection, but he submits that the applicant may be allowed to withdraw the amount subject to furnishing one bond. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application is then allowed.
And also minor.
Subject, however, furnishing one bond of equal amount before the rest of this.
8,99,600.
And further,
Four
Mr. Gogoi shall furnish amended cost title in this application relating the name of respondent number 7. Respondent number 7. Amended cost titles. In terms of above, this IA stands for disposal.
Only
Obligations.
submit one thing. There are minor lordship. Respondent number 5, 6, 7 are minor. Minor interest will be protected. Otherwise, lordship it is withdrawn. Minor may not take.
No. Is there any direction in the?
No, only commissioner don't take. But
There is no
please go direction. Minor right to be protected always.
No.
Minor.
Whether we can pass such a direction in this IA.
Lordship only to make fixed deposit, lordship. Only to make fixed deposit in the name of minor. According to their share. Rich will make fixed deposit in the name of minor.
No. The share has not been apportioned.
No.
Then.
As per Supreme Court, the order lordship, the minor right always should be protected. Otherwise.
No. That's all right. But this is not the trial court, no?
That's it.
We are in the appeal.
Appeal is a continuous process.
No, that's all right. But at the time of final hearing, we can consider the
Okay,
same.
the final-
And definitely we will consider the same. But in
Understand,
this
okay.
IA.
Understand, lordship. Only thing is lordship, amount is 50% is withdrawn. Then lordship, the minor interest will be not protected.
No, in the remaining amount, we will consider the same.
What's in the remaining amount lordship?
Mm.
She is the
Lordship,
mother of the minors lordship.
Consider at the time. Final
Okay.
disposal.
Uh,
Otherwise, lordship, it will
interest of the minors being respondent number 6 and
1 to prove 6.
2 to 6 will be protection of interest of the minors being respondent number 1 to or 2 to 6 shall be considered at the time of final disposal of the appeal.
MFA lordship.
Obligation.
Obligation.
Maximum cases, lordship, the money has been taken by share.
But yes, he is a mother of the minority.
That's right, but this interlocutory application without such pair being made, how can we consider?
That is what. 36.
Obligation.
Yeah, and in this case, the applicant had no deposit of 50% of the applicable amount till date. Only as per the earlier order of this available court, a meager amount of 3,000 is deposited. The case is of 2025, now 26 running around. The respondent is a lady with a
For the respondent.
yes, Your Lordship.
Office note dated
Your Lordship,
29/1 2026 indicates that trial court record has been received.
Lordship, there's a stay order operating.
Yes, Your Lordship, but without depositing the 50%.
Since the matter is ready, no, since service in this matter has been completed and TCR has also been received, rest is the matter for hearing. Immediately after vacation, learned counsel for the respondent submits that though there is direction for depositing 50% of the
Your Lordship, there was a direction to deposit 3,000. 3,000 only.
3,000.
Yes, Your Lordship, as per the earlier order, I'm sorry, I have not recorded. It is in the record, Your Lordship. Only 3,000 is.
Made business, Your Lordship. Lordship, as per office note dated 10/6/26, respondent number 1 to 3 have filed wakalatnama. And 4 process server report, sister-in-law has received, Minara Begum has received the notice. Lordship, otherwise this is a delay petition of 96 days delay, Lordship.
Yes, any objection? No objection. Heard Ms. Mazumdar, learned counsel for the applicant, Mr. Agarwal for respondent number 123. Office note dated 10/6/2026 indicates that service upon respondent number 4 stands completed. Ms. Mazumdar submits that this interlocutory application is preferred for condonation of delay of
97 days, Lordship.
97
96,
days,
sorry, 96.
96 days in preferring connected appeal against the judgment in order dated 21/12/2024 passed by the learned member Motor Accident Claim Tribunal Dhuri in MSC case number 77 of 2022 within bracket D. Ms. Mazumdar further submits that though the judgment and order was passed on 21/12/2024, the appeal could not be preferred in time. What is the ground?
Lordship, paragraph 3, 4, 5, 6, and 7. First of all, Lordship, we received the legal opinion after 129 days. Thereafter, immediately within the on 29/4, then 2/5, it was forwarded to the regional office. Then, Lordship, on 13/5, legal opinion was given by the council. On 25, competent authority approved. Then, Lordship, I had to go for a training, Lordship, MCPC mediation training. I'm also a trainer, so I could not file that. Some time was taken by me, Lordship. That is paragraph 7.
Submits that though the judgment was delivered on 21/12/2024, yet the appeal could not be filed in time as the applicant herein had to obtain legal opinion from where you have obtained legal opinion?
From High Court Council.
From the Council of the High Court, and in the process there was some delay, and there was also some delay on her part as she could not prepare the same on account of her
Yes,
preoccupation with mediation training organized by the MCPC Supreme Court of India, and the delay is not intentional, and under such circumstances he has contended to condone the same and to admit the appeal. Mr. Agarwal, learned counsel for the respondent, opposite party submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, and also in view of the explanations so forwarded in paragraph number 3, 4, 5, 6, and 7, this court is of the view that the delay of 96 days in preferring the connected appeal is sufficiently explained, and accordingly the same stands condoned. In view of the order passed in this IA, now the registry will proceed to register the appeal and list the same before the court as soon as practicable.
On 22nd, Lordship, because it is on quantum, Lordship. I mentioned this case because of that only, because of Bakija proceedings.
You go to the registry, file an application there.
Highly obliged.
If the registry lists the matter on Monday, the court will take it up.
Okay. Highly obliged.
Okay, Mr. Agarwal submits that his name has not been reflected in the cause list. Reflected in the main appeal. Accordingly, it is provided that registry shall do the needful in this regard. Yes.
Obliged.
For admission, I do one order matter.
May I please proceed? Kindly pass over the name. Proceed, kindly pass over the
Yes.
name for instruction from the client.
Pardon?
for the instruction from the client.
You are appearing for?
RC Das. Petitioner.
He is absent today?
Yes, Lordship.
So he is not present today.
No, Lordship.
Heard, mister? Your name, please?
H. Rahman.
Learned counsel appearing on behalf of Mr. Arsitas, learned counsel for the petitioner, Mr. Fukon for respondent number.
For the elementary education. And for the elementary education.
Learned counsel appearing for the elementary education department, Mr. Gogoi for SSA. SSA. Since conducting counsel, Mr. Arsidas is absent today, let's just list the matter. After vacation? After vacation.
Item 2, order.
For last order, I was also instructed to bring information regarding the petitioner matter. Yes. My lord, your matter is an secondary document. Personal commission of chapter secondary. School matter got amalgamated matter. So
What was the issue?
the issue, my lord, regarding pension, my lord.
Pension of the petitioner, my lord, regarding the. Petitioner is a
Pension of the
drop teacher,
petitioner.
my lord,
Pension of the petitioner.
my lord. Monthly pension. That was already determined by this honorable court, my lord, in WPC. What? Double two.
No, what is the pair in this petition?
My lord. Prayer, my lord, your lordship may kindly. Page 17 and 18, your lordship. Now I am pressing on prayer number 2, my lord. For a direction to monthly pension, my lord.
Monthly pension.
My lord.
You have not received.
No, my lord. Till date I have not received. And I have prepared, my lord, with a brief notes, my lord. I to prepare your lordship, ma'am.
No. The provincial particulars of the This information which I given, this current status, well, that is the information which was there before the prior to amalgamation. Because now the school has become amalgamated, it comes directly under the secondary domain of the secondary education department. That part may not regarding the pensions. Here only may not have information regarding whether the teacher has rendered at least 2 years of continuous service immediately preceding the taking over of the concerned school. Not given yes. Then by not whether appointment whether the appointment is approved by the district elementary education officer, yes. As on 27/5/1988 before the provincialization of the school. And then whether the appointment made by the
When the school was provincialized.
yes, sir. And whether the school-wide sanction post norms was maintained at the time of provincial election. That by not given received low. There were 4 teachers at the provincial
And my lord, provisional, the last, second last and last. The second last and last column, my lord. There, my lord, again, given provisional in particular submitted by the DEO available in the concerned directorate. No. So these two, my lord, the last part, the second page. So that part is they have given no, in those two. So that part, my lord, I think the information has to be taken from the secondary education. My lord. No? So, because the is amalgamated now with the secondary education, no longer, it's no longer.
No, whether he is entitled to pension or not.
Exactly, man.
I am entitled for pension, my lord, because of this honorable court's order, my lord. Entitlement is there, my lord. Because my lord, petitioner is a drop teacher. At the time of provincialization of their service, my lord, they were dropped, my lord. Subsequently, in the year 2012, their services were regularized, my lord. And they have provided with a new pension rule, my lord, which they have challenged before this honorable
No,
court. which
when
I
your
have,
service was provincialized,
my lord,
when your service was provincialized,
my lord, that
before
is I have annexed, my
2005,
lord. Your lordship may page 44, your lordship may found. In my petition, my lord. 21st February 2013.
with effect from,
My lord,
with effect from,
with effect, my lord, from the 2013, my lord, since they are drop teacher, my lord. So they have been accommodated with the new pension rule, my lord, which they have challenged before this honorable court. And
where is the order of this court?
your lordship, my lord, page 52, my lord.
52.
There is type copy and original order is that page, my lord. 55. His
55.
name at serial number 9, my lord, page 55. Convolution theory, that is the petitioner, page 55, your lordship. And operative part, my lord, starts from, my lord, page 58 and 59, my lord. This honorable court already, my lord, held that the petitioners are entitled for Assam Service and Pension Rules in terms of the Jiban Chandra Supra, my lord. So entitlement is there, my lord. Page 58, my lord, it is submitted. And in the last paragraph, my lord, page 59, the aforesaid decisions considering the entire aspect of the matter state has been directed not to insist upon the undertaking from the petitioners as contained in their respective improvement appointment regulation orders.
Now, what is this? The matter is pending.
My lord. But they will not claim, my lord, their area salary, my lord, only in respect of pension, my lord. I have shared a gist, my lord, about the appearance and instructions, my lord. On every occasion, my lord, they have either secondary education or elementary education, my lord. Just going on.
And that Gibbon Chandra Supra, my lord, that is which earlier judgment, my lord, relied this honorable court, my
Hmm.
lord.
No, Mr. Pokon, you say this page number 57, the order of this court.
Well,
In page number 59, it is provided that the petitioner is entitled to benefit of past service for the purpose of pensionary benefit as per Assam Services Pension Rule 1969
well,
in terms of the direction contained in said Jiban Chandra Dekka's case.
well,
So this order perhaps attained finality.
final.
So he is entitled to pension. There is no doubt about it. Now, at what stage the process is pending?
Now at the moment, on the last occasion, you have asked us to bring the details of as to the his it is amalgamated by law. After the second day was asked us on the last occasion asked us his previous record when he was at elementary. So I have produced it before that one report, and according to my the other part of the pension is supposed to be paid around.
Page,
So another day November. The fixed come under the secondary. That is why that is for pension. It is not.
Pardon?
Is that to
Entitled.
pension? Yes, but it is that one part of which happens on another direction of elementary education. Only the director of secondary education support strategy education. Today, also my friend has produced that report before the national court. So I have to communicate that report to the department. It is not communicated to the department till today.
No, this is addressed to the commissioner and secretary.
Commissioner secretary, let's see. So
Yes.
that report, what the action, the director of secretary, commissioner secretary has taken, that instruction I have not, let's see.
So you have to obtain that instruction. Okay.
always for a moment, my lord, your lordship may kindly page 66 in my repetition, your lordship may found. That is the issued by the director, elementary education.
Page number?
Page number 66, my lord.
Page number?
66, my lord.
Okay.
In pursuance of the government letter number such and such, and for the compliance of honorable court order that which I have already relied, my lord, to 4 of 2013, the past service of the following assistant teachers are hereby allowed counting towards pensionary benefits as per Assam Service and Pension Rule. My serial number is at page serial number 9, my lord.
Yes, that is there.
That has been approved by the Pension and Public Affairs Department. The last line, my lord. This has been already approved by the Judicial Department computer version conveyed such and such number. Now they are delaying, my lord.
Let Mr. Dotto obtain instruction in respect of this letter.
My lord.
In respect of this letter, which is produced by Mr. Fukon before the court today. Mr. Fukon, furnish a copy to him.
I'll give you a copy.
And also heard Mr. P.P. Dotto, Learned Standing Counsel for the Secondary Education Department, being respondent number 1, 2, and 6, and Mr. Fukon for respondent number, no, for the respondent in Elementary Education Department, being respondent number 5, 7, and 8. Mr. Fukon submits that pursuant to the order dated 29/5/2026, he obtained instruction in respect of the letter dated 27/5/2026. And as per his instruction, the requisite information has been forwarded by the Director Elementary Education to the Commissioner and Secretary. Commissioner and Secretary to the Government of Assam Department of School Education. Mr. Dotto, Learned Counsel for the Secondary Education Department, however, submits that he may be granted some time to obtain instruction in respect of the communication dated 27/5/2026. They are allowed recessal list the matter after vacation. After vacation. Mr. Dotto, Learned Counsel for the Secondary Education Department, Learned Standing Counsel for the Secondary Education Department shall obtain necessary instruction in respect of the pension file of the petitioner and also in respect of the letter dated 27/5/2026 and apprise the latest status before this court on fixed date 24th July.
In the, my lord, almost 1 month, my lord. In the meantime, they can also settle, my lord, your lordship, some of the.
Pardon?
My lord, they can also settle my pension also, my lord. 1 month they have given time, my lord, since to.
They will settle definitely. They will obtain the status and apprise this court.
Obliged,
Mr. Alam, you keep this with you.
my lord.
At the time of final hearing, it will be necessary.
Deeply.
Complete করলাম তুমি। So on the other day, we have completed the hearing.
Yes, my lord.
Today, we are pronouncing the order. Is appeal allowed? MP in order. Set aside and quash.
I'm deeply obliged.
Okay.
In the revision also, my lord, common order.
Pardon?
This item is the CRP.
Yes,
is-
common order.
Oh, common order.
It is interfered with
Yes, my
in
dear.
appeal.
Yes,
No order is required to be passed in CRP.
yes. I'm deeply obliged.
Right. Item number 34.
Doctor. Application. So on the last occasion, your lordship directed them to obtain instruction where my proposal is
Mr.
pending.
Soliha.
Okay, yes.
Soliha.
Is financial.
Okay. Inform Mr. Soliha.
Okay.
Okay, after some time.
Item 5.
May I please, your lordship? 482 bail application, lordship. Matter is charged, lordship. Trial is initiated before the Court of Civil Justice Junior Division Court number 2, come JMFC Hailakandi, lordship. Now, initially, lordship, this case was registered as Katlisara PS case number 109 2022 under section 120B 342 325 307 of IPC, and subsequently, as the victim died in medical, lordship, 302 was added, lordship. So during the investigation period, lordship, I, lordship, approached before this honorable court for AB, lordship. And this honorable court has granted me the privilege of interim pre-arrest bail on lordship 2507/23, lordship. And accordingly, I appeared before the IO. My statement was recorded, and the police allowed me to go on police bail, lordship. Thereafter, lordship, subsequently, upon hearing of the bail petition on 23/08/2023, this honorable court pleased to reject the bail and vacated the interim order, lordship. Subsequently, lordship, the matter was charge sheeted and the trial is initiated in before the learned court below, lordship, and summons was issued, lordship.
So,
And
we will issue direction to you to appear before the learned trial court, apply for regular bail,
lordship,
and in the event of filing such an application, the trial court shall consider the same in accordance
lordship,
with it.
similar matter has been
Pardon?
the coordinate bench of the dishonorable court has passed in similar situations, lordship, granted bail, lordship, on appearance, lordship.
On appearance.
Yes, lordship. So
Yes, Lordship, 302 is there, Lordship, and it is a committal court, Lordship. So there is an apprehension, Lordship. If I appear before the Honorable Court without protection, I may be arrested, Lordship. On similar some circumstances, coordinate bench of the this Honorable Court has protected, Lordship. Lordship, I will face the trial, Lordship.
What are the sections here?
Lordship, the 302 IPC, Lordship. In that particular cases, 303 is there, Lordship.
Under section 191. Mr. Das? Oh, you may not be aware of this, because this is another.
As Lordship, Lordship, another order I have given, Lordship, where 302 is there, and Lordship, embargo of section 481, subclause 1, Lordship, of BNSS. The committal court may not grant bail on appearance.
This is the case, Lordship, authoritative.
Hmm.
So it has to be gone on merit, Lordship. If I go by merit, Lordship, there is in the charge sheet also, Lordship, it is clearly stated that may I read few lines, Lordship.
Hmm.
In the last line, on examination of the scheme, before this date, the victim stated that he has assaulted by 5-6 numbers of persons, of whom the accused, the present petitioner, was identified the victim who tied hands and feet of the victim. So it is a dying declaration to be considered as, because he died, Lordship, this statement is there in the victim.
But
That will be considered by the trial court at appropriate stage. So according to you, there are materials against it.
Lordship, and moreover, Lordship, I want to take a few also, few lines, Lordship. It is fixed for appearance because, Lordship, till 11/6/2025, summons has not been returned, and after that, Lordship, absent, they took the plea of absent, Lordship, and filed petitions, Lordship, on 27/8/2025, 17/11/2025, 2/6/2025.
No, what happened, Lordship?
Remaining absent, so it is the prosecution.
Lordship, what happened?
Has not been proceeded, Lordship.
Lordship, what happened? We approached the Honorable Session Judge, Lordship. Bail petition, I have annex, Lordship, page number 36, Lordship. The rejection of the bail petition, Lordship. Thereby I was absent, Lordship. I approached before the learned Session Judge Hailakandi, Lordship. That bail petition was rejected, my PS bail petition, Lordship. That was rejected on, Lordship, 11/26, Lordship. So thereafter, Lordship, I approached before this Honorable Court, Lordship. Since
No, you say
Lordship, what happened, Lord?
offense is under section 302 IPC.
Yes, Lordship.
So
The order, Lordship.
once this court has granted interim protection to you,
Yes, sir.
and subsequently after perusing the case diary, your petition was dismissed.
Yes,
And interim order was vacated.
Yes, Lordship.
Now, is there any change of circumstance in your favor?
Lordship, what happened? The police, after rejection of this bail petition, Lordship, earlier bail petition, Lordship, police did not arrested me, Lordship. And in the
No,
search
is
sheet,
it the change of circumstance in your favor?
yes, Lordship.
Is it?
Yes, Lordship. And the police saw me as the police on police bill. I am on police bill, Lordship. Not declared me as an ex-absconder, Lordship. Since, Lordship, my humble submission is that, Lordship, since 481 surplus 1 embargo is there, Lordship, the committal court may not, Lordship, grant me bail, Lordship. So, Lordship, since the coordinate bench of this Honorable Court has really given relief to the petitioners in different cases, Lordship, I mean,
The different case of whether the nature and gravity of the offenses are
yeah,
similar.
Lordship, BA number, Lordship, I have given 2830, Lordship. So, this similar, Lordship. In
Two?
this particular case also, Lordship, 302 is there, Lordship.
BA number?
BA number 2830, Lordship. Where where the plea was that the embargo is there, Lordship. In that circumstances, the coordinate bench of this Honorable Court has granted the relief, Lordship.
Okay, we'll see. We'll see. In that case, some of the co-accused have been granted the privilege of participatory bail.
Lordship,
Is it your case here? No.
Lordship. Lordship, I have to pay with Lordship.
Yes.
Lordship.
Pending 34.
I'm obliged, Lordship.
Where in this matter, Lordship, on the last date, it was submitted that a proposal for pay parity, for pay protection was forwarded, Lordship, here on 6th of May, Lordship, we had raised this query, Lordship, will just go through this endorsement, Lordship. This we have not received back. I have inquired from the office, Lordship. This was
From which office?
from which office? Education Department. Lordship will see, this is an endorsement of 6th of May, Lordship. The proposal was incomplete, certain joining report was, I think, and we had just asked for these to properly educate the matter. That was the endorsement. But lastly, Dr. Lordship, I was asking for something written from the department saying if they state clarified all this and sent it back, Lordship, but we have not received anything.
Doctor?
That matter also, I have, on the last occasion, I have given 3 seats also. That inspector of school has already verified that on 16 lordship, I submitted my joining and lordship release order. There is no one in the headquarter. So the inspector of school released me on 19th. That order lordship, 9/6/2025. I've already placed it on record.
Lordship, there's a instruction. It's
One instruction I have with him. That officer provide equity inspector to provide the application of information to this center for. Yes, proposal for pay protection shall be resubmitted on receipt of the report from the inspector, Lordship. That report from the inspector is awaited.
Lordship, inspector's letter 9/6/2025. It says that it is
We have submitted.
No, Mr. Dutta,
Lordship.
inspector has submitted the report on 9/6 of
2025.
Lordship,
Only with regard to 3 days, Lordship. I joined on 16, Lordship. No one was there in the headquarter. Then the release order came on 19, Lordship. 17 and 19. So they should treat it as a 16, Lordship. That's a simple thing, Lordship. For this, Lordship, 3 days, Lordship, they are issuing letters after letter, Lordship, clarification and.
now whether the inspector has forwarded the report.
Oh, Lordship, as per your Lordship direction, Lordship, I obtained these three letters, Lordship, from the inspector of schools. These 3 letters have been provided to me. My joining letter, which has been endorsed by the inspector. Then Lordship, my release order, which has also been endorsed by the inspector of schools. Then Lordship, the letter by the inspector of schools to director of secondary education, which says that Lordship, on 16, I have submitted my joining and release order, but there was no one in the headquarter. So after the release order was issued on 19th September 2024.
No,
3
that's
days.
all later. You have been released with effect from 19.
19.
Lordship, my last instruction on 4/6/2026. On that day, Lordship, the deputy director has again asked the inspector of school to submit report. And my learned friend is holding that report, Lordship, of 9/6/2025. So I will, so, deputy secretary of the government director.
Lordship 4626, the deputy director has wrote a letter to the inspector to submit a report as been sought for by the department. Now the question is, you are representing the inspector also.
Yes, Lordship.
You asked the inspector to furnish the report
The
then.
inspector has not sent any report till today, Lordship, as per my instruction.
No, you asked the inspector,
Lordship.
since you are representing
Then I
him,
can do that.
or should we direct him to remain present in the court?
But I will,
When?
I will ask Lordship.
No, because of this simple matter, she has been filing writ petition after writ petition. What is this?
Proceed, Lordship, but I will, let me communicate with the inspector once, Lordship.
Heard, Mr. S.K. Das, learned counsel for the petitioner. Mr. Dotto, learned counsel for the respondent in secondary education department, and Mr. Soliha for the finance department. Mr. Soliha has produced one office note. Is it office note, Mr. Soliha? Office note of the finance department dated, this notice of dated 6/5. 6/5/2026, and submits that due to inconsistencies in respect of the date of release, the department was requested to resubmit the proposal along with search-taking report and other supporting documents, if any, for proper examination of the proposal. And thereafter, the finance department has not received the report, not received the proposal from the Director of Secondary Education. However, Mr. Dotto, learned counsel for the respondent in Secondary Education Department on instruction, submits that the director has not received, no, director has requested the inspector of school, Kasar, for submitting the proposal along with the relevant documents, and the same has not yet been received. However, Mr. Dotto submits that he may be granted some time to obtain inspection from the inspector of school. Where allowed, recessal is the matter. When?
As per lots of convenience.
So, after vacation,
After vacation.
List the matter on 27 July. In the meantime, you obtain the instruction from the inspector of school. And you ask the department to process the same as early as possible and transmit it to the finance department. Further, it is provided that Mr. Dotto shall obtain the requisite information as well as the proposal from the inspector of school, Kasar, and also ensure resubmission of the proposal to the finance department in the meantime. The letter produced before the court today by Mr. Soliha shall be placed on record by marking the same as annexer B. Annexer B.
Obliged.
35.
So Lordship, prior to 1999, give me that, Order 41, Rule 1, what was it stated? Clearly stated that appeal will be filed. Where is Order 41, Rule 5. Order 41, Rule 1 says forms of appeal. What to accompany a memorandum of appeal? Every appeal shall be preferred in the form of memorandum signed by the appellant or his pleader and present to the court or such officer as may be appointed on behalf. The memorandum shall be appealed by a copy of the decree appealed from. That was prior to 1999. Thereafter, Lordship, 99, there was an amendment from which was given effect in 2002. now what effect has done, it has done is that Order 41, Rule 1 says, from the a form of appeal, what to accompany the memorandum. Every appeal shall be preferred in the form of a memorandum signed by the appellant or his pleader to the court or such officer as it appoints. The memorandum shall be accompanied only by a copy of the judgment. So that has been amended in 2002. That effect has come in 99. It has been given effect in 2002.
No, you see the heading, appeal from original decree.
Right, correct, Lordship.
Then,
So this is an appeal under Order 1. Original decree is the order dismissing my appeal, my suit. That is the original decree.
so if the decree is not prepared, then
I can file with the judgment, with the copy of the judgment, not the decree, because decree takes long, and this was also considered by the Kerala High Court.
no, that's all right. But whether decree was prepared or not.
Decree has not been prepared.
So if the provision requires the appeal should be preferred against the decree is not prepared.
So, Lordship, but that has been amended now. Amended, and we have to file under Order 41, Rule 1. Order 41, Rule 1 says judgment, and we have been filing, Lordship, only with the judgment. It's not the first time. Even Kerala High Court has cleared it, said after 99, this has been a revolutionary amendment where appeal can be filed against a judgment, and this is in line with Order 20, Rule 6A also.
You produce the decision of the Kerala High Court. We will examine.
I'll give you, Lordship. Where was it? Lordship will come. Paragraph 4, quoted Order 41, Rule 1, as it stood before the amendment at the third page.
Here, paragraph number?
Yeah, paragraph 4. Paragraph 4, Lordship will do. Order 41, Rule 1, as it stood before the amendment. And then after the amendment. And then Lordship will find at the next page. Lordship will come to the next page. The amendment in paragraph 4 itself, the last part, the amendment of Order 41, Rule 1 of Rule 1 CPC by Act 46 of 1999 was conscious to be in tune with Order 20, Rule 6A of the CPC, and hence the memorandum of appeal need be accompanied by the copy of the judgment only. So it's very specific. And when this order says so, only judgment and a conscious omission of the word decree, judgment and decree. Decree has not been prepared, otherwise there was no question of not filing the decree. And Lordship will go to order 20, Rule 6A also, which clearly says that I can file without a decree if it's not prepared.
Okay. We will examine the matter. We will not pass any order today.
Lordship will look at order 20, Rule 6A, which says Rule 6A 2. An appeal may be preferred against a decree without filing a copy of the decree, and in such case, the copy made available to the party by the court shall, for the purpose of the Rule 1, Order 41, be treated as a decree. So against the judge, Lordship, it's been done all the time now after this amendment. Even if the decree, because decrees are not drawn up immediately. That fact, the legislature was
Okay. We'll examine the matter. Heard Ms. M. Hazarika, learned senior counsel assisted by Ms. Learned counsel for the appellant. Order reserved.
Otherwise, the office also would not have passed my
Pardon?
appeal. Office also would not have passed my registry, would have not have passed it.
No, maybe we will see.
Hearing. Item number 32.
Please, Your Lordship, my senior is on legs, in group number 16. He has some very short
Okay,
submission.
here we have already completed the argument. So today we fixed the matter is listed today only for judgment today.
Learned friend has completed his argument, my lord.
No, you also completed.
Yes, all of us. Yes, completed reply, that's what I'm saying.
Your Lordship, may I take the matter at 2 p.m., my lord. He just has some very short submission.
No, nothing to be heard here. Hearing already completed.
Right.
Since you are present in your behalf, it is sufficient for the court. This court has framed as many as 4 substantial questions of law, but none of the substantial question of law found to be flows out of the impugned judgment and decree. So passed by the learned first appellate court. In the result, the appeal dismissed.
Deployed.
Right.
Item 33.
Please, legal Lordship.
Yes, Mr. Goswami, what is the matter?
Lordship, this is basically on the quantum aspect right now, Lordship.
Quantum.
Quantum, Lordship. This has been heard already.
Pardon?
This is already heard earlier. I have placed the judgment, also copy of my judgment. Lordship.
Already heard by another court.
Yes, Lordship.
What has happened in this case?
Should we go for hearing again then? The resume lists the matter before that court if it is part-heard matter.
Not part, my lord.
Not
Not part.
personal. I don't know.
Patan, not Patan. Fixed for today for hearing.
Earlier judgment was reserved. 5/12/2024. Thereafter, what happened? It was released.
My lord.
It's been hard on several days. Oh, yes, Lordship.
In 24, it was heard. Judgment reserved. Thereafter, it was released.
Yes, my lord.
In the year 25.
Yes. Today, quick fix for hearing only, my lord. It is not part, my lord. It's
Not
for
part.
hearing.
hard bull है कुछ पता नहीं करना है.
No, the question is if one of the bench already heard the matter at length, the matter would have been listed before that court.
On the last occasion, my lord, I have gone for the order, my lord, that because of procedure of time, matter would not be heard. I'm fixed for today, my lord, for hearing. We have some other.
No, you say hearing could not be concluded. It means the court has heard the matter.
My lord. But not part, not part. Lordship may taken up, my lord. This lordship may taken up. That is for lordship.
Yes, Mr. Goswami. Basically, upon the quantum.
Quantum Lordship, what is the wages of the ye?
Wages of the
deceased Lordship. He was
deceased.
18-year-old boy, was a handyman of a vehicle Lordship.
He was a handyman of truck or
vehicle.
bus.
Lordship, I'll straight away come to the evidence.
The vehicle was truck or bus.
It was a truck Lordship.
Truck.
Truck. Truck.
And what is the substantial question of law framed in this matter?
That's one question of law in page 5 of my memo. Lordship.
No. In the order.
My lord, with all due respect, my lord, this appeal was admitted without framing the substantial question of law. And
But in this kind of appeal,
yes, my lord, that is mandatory. Substantial
It
question.
was
has to be framed.
incorporated in my memo appeal Lordship, but honorable court just admitted the appeal.
No, whether you have pointed out at the time of
Yes,
admission of
Lordship.
the appeal.
This was admitted, discussed and admitted, but then Lordship, it was omitted. I have this in my
It
page
is
5, it's a
admitted for
substantial
hearing.
question of law I have framed in page 5.
And there is a requirement of framing of substantial question of
Yes,
law.
sir.
Which section provided?
Section 30, my lord.
30.
Yes.
Workmen Compensation Act.
Yes, my lord, please, yeah. The list of orders are there also, which are appealable. And also, my lord.
Workmen and employees. Employees or workmen? Employees compensation.
Employees compensation. Earlier it was worksmen, now it's employees.
Section?
30, my lord.
Section
It's number 39.
And what are the substantial question of law you have suggested in the memo of appeal?
Lordship, in page number 5.
Page number 5. But he can fix the notional income. He has the authority to fix the notional
Yes,
income.
Lordship, but in this case, the evidence of the claimant was that he had received at a maximum 5,000 rupees per month, Lordship. Lordship, the judgment that I have referred to and it's in the record, Lordship, it says as per actual wages. As per actual wages and Lordship, in that case, I'll have to take your Lordship to the evidence, Lordship.
No, Mr. Lusami, you see,
Yes.
if there is no such document, then
Yes.
If there is no such document, then
Then-
it will be a question of Lordship, minimum wages, as your Lordship has said. But in this case, the evidence before the commissioner, Lordship, was that the mother had deposed, and being almost a minor, Lordship, mother is the only person who can probably say the employer did not come before the commissioner to give evidence about the wages. The mother said her son used to go for 4 to 5 trips a month, going with the truck and coming back, Lordship. So we'll take it on the higher side as 5, Lordship. I'm just quoting verbatim from the evidence, Lordship. And he used to get 700 to 800 rupees per trip. If it is even his higher side, highest number of trips, 5 trips per month, and the highest amount, 700 to 800, then it comes to, Lordship, 4,000 per month, Lordship. And as per the judgment of the Supreme Court that I have already placed on record, it should be on the actuals. If the actuals is 4,000, the court has some material before it. The mother's deposition before the commissioner. That 4 to 5 trips per month and 700 to 800 rupees per trip. So that makes both on the higher side, 5 into 8 is 4,000 rupees per month. It will be taken as 12,000. Because, Lordship, wages is a question of fact. And unless it is proved with evidence, it cannot become a finding of fact. Only when it is a judgment of, I'm all saying from the side, judgment of Supreme Court, it has a proved with evidence to make it a finding of fact. Otherwise, it's a question of fact. So evidence, Lordship, the affidavit filed by the claimant is the only evidence here, Lordship.
My lord,
And affidavit also, Lordship, says that she doesn't know what was written in the affidavit. So now it all is reduced
may
to,
not know. You
it's there. I don't know what is written in the affidavit.
Mr. Goswami, you visualize the situation.
Yes, Lordship.
Whether such woman
Yes, Lord.
of a remote village can understand the English language drafted by
That's
advocate.
what, I mean, it has to be explained to her. Even that statement ought to have been there from the advocate. Okay, I had explained everything. Even that statement is not there. Lordship, I agree with your Lordship.
Mr.
That it is
Goswami,
the
you say
minimum wages of that particular time, Lordship.
pragmatic approach has to be
Lord.
adopted.
I fully agree. Lordship, in that case, minimum wages may be considered of that particular
Anyway,
case.
here first we have to frame the substantial question of it.
Yes, Lordship. Lordship may frame it.
my lord, so far as this, my lord, income is concerned, my lord, 12,000 that has been executed by way of, my lord, exhibiting the salary certificate that has been filed by the employer, my lord, itself. And the employer, my lord, in his WS, my lord, it is admitted that he is, my lord, issuing a salary certificate, and the salary of the, my lord, receipt is 12,000, and he is giving, my lord, 150 rupees additional benefit. So, my lord, as per the section 58 of evidence, fact admitted, my lord. Fact admitted need not be proved, and that has been
No, the certificate was exhibited.
Certificate was exhibited in the record. And also, my lord, that the employer himself filed an affidavit, filed that, my lord, in his reject settlement, he has admitted, my lord, that his salary is, my lord,
Heard Mr. Goswami, learned counsel for the appellant, Mr. B.R. Das, learned counsel for the respondent. During the course of hearing, It has been pointed out that while admitting the appeal, by order dated
Certificate is not in the report. No, but statement is a debit.
9/9/2021, no substantial question of law was framed, although proviso to section 30 of Employees Compensation Act 1923 requires framing of substantial question of law involved in the appeal at the time of admission. Accordingly, after hearing learned counsel for both the parties, following substantial question of law is framed. Number one, whether the finding recorded by the learned commissioner for employees' compensation in respect of assessment of wage of the deceased suffers from perversity. Accordingly, arguments of both the parties were heard. Both the parties are heard on the point of substantial question of law. Argument concluded, judgment reserved.
Lordship, Lordship, I have to, Lordship, give a date for hearing, Lordship. I have to say, make more submissions.
You want to argue more?
Yes, Lordship. So Lordship may fix a date, both of us.
I submitted the submission and the honorable apex to paragraph and honorable apex to have even though my water party fails to submit any proof of wages or income, then the commissioner has by way of application office mind can determine the income of the artist. So in the cases where
Okay. If Mr. Goswami argue the matter again, then okay, all right. This is the matter on for further hearing. Okay, let's list the matter as part of some urgency were there. Anyway, immediately after reopening, then 14 July. Part